Hello everyone and welcome to the Dingley Marshall webinar. I hope you've had a chance to have a look at our page. The page was set up in the last week or so as a result of the coronavirus and COVID-19 crisis that we're dealing with. We realized that a lot of businesses and local businesses and individuals and firms are affected by the current crisis, and we thought as a way to give back, we would set up a YouTube channel where we can do educational sort of discussion forums on the crisis and the legal effects, and we'll be offering these webinars over the next few weeks. I am joined in Cape Town by my associate Peter Turner.
Hi everyone.
Peter will be discussing a few specialist topics mainly related to labor law questions which arise out of the COVID-19 crisis and employment issues. I'll be focusing largely on contractual and civil issues that come about as a result of the crisis. What we'd like to do is encourage as much discussion and as much interaction from you as possible, so please feel free to post comments and we'll try and answer as many questions as we can in the time that we have. It's probably important, and you would have seen from the channel description, that this is not meant to constitute legal advice. This is supposed to be a discussion forum. It's our attempt to give back and to assist businesses and individuals in need. And we do encourage you, if you do have a specific legal question or an issue which you'd like to discuss, then please get in contact with us. You'll see our contact details and our website are linked on our channel page and also on this live stream. Peter, as you and I have been discussing, you've been focusing a lot on the employment issues which have arisen out of the COVID-19 crisis. Perhaps you'd like to comment on some of the work that you've been doing.
Cool. Hi everyone. As I'm sure a lot of you, and especially those of you who operate small to medium-sized enterprises, have found out over the last couple of weeks, this is the COVID pandemic is obviously very new, very novel, and most legal systems just simply were not prepared for it. So the first few weeks of this particular pandemic, and especially after the declaration of a disaster or state of disaster by the president early in March, labor lawyers especially have been running around like chickens with their heads cut off, trying to assist clients who needed urgent advice as to what to do with their staff. How do they ensure that their staff are adequately provided with work? How are they adequately paid, especially in these times where work is scarce? Now, the situation before the declaration of a disaster, and especially the declaration of the lockdown, was reasonably muddled. So in that instance, we didn't yet have a declaration by government that all non-essential companies were to cease trading and cease their operations. It was simply just companies trying to take preventative steps to ensure that they have their ducks in a row when the lockdown eventually hit. Now that it has hit, it has clarified the situation for employers somewhat, in that the regulations that were published in terms of the Disaster Management Act, in terms of Rule 27.3, stated that all non-essential businesses, and non-essential businesses are defined in the regulations, are to halt and suspend their operations immediately. So this would normally be businesses that do not work in the grocery sphere or in medical facilities, medical services, that type of thing. Pet products, unfortunately for most of us, alcohol has been excluded by this. So what this eventually means is that an employer is legally obliged, especially small to medium non-essential services, to halt their operations. This obviously has a huge impact on the profitability of those enterprises for the next couple months, depending on whether the lockdown is extended or not. And obviously then in turn on the employees of those particular employers. So our initial advice to clients who approached us with this type of issue, where they said, listen, I'm closing my operations, I've been forced to do it, or I've got one main client that is based overseas, and that particular overseas jurisdiction has enforced some form of lockdown. They can't operate, therefore we can't operate, and therefore we can't pay our suppliers, our creditors, our staff. So there are a few options open to clients, and this was recently discussed in an article that I drafted and put up on our website, which you can consider at your leisure. And essentially, what it comes down to is some form of agreement with your staff. There is one exclusionary rule or one exclusionary option available to employers, but very few employers actually have this particular mechanism utilized in their employment contracts. And this is where an employer is unilaterally given the right to reduce working hours and therefore reduce payment in response to these types of unforeseen circumstances. Now, this is not the type of provision that is commonly found in employment contracts, and very few employment contracts have this type of provision made. So if you are one of the employers who find yourself in a situation where you run a non-essential business and you are in a situation where you simply cannot pay your creditors and all your staff, there is some glimmer of hope at the end of the tunnel. So what we have recommended to our clients recently is that they try and engage with their employees and reach some form of agreement whereby they either agree to pay or to send their employees on annual leave, and therefore still pay them for the days that they accrued in terms of the annual leave. And then once those days dry up, and depending on the length of the lockdown, then the shift or the focus can shift to an unpaid leave of absence. But on the other hand, many employers do not have the means to pay for their annual leave days taken. So the majority of employers have reached some form of agreement with their employees whereby there is an extended unpaid leave of absence taken. The good thing for employees in this particular agreement or arrangement is that they remain employed, and that as soon as the lockdown is lifted, the non-essential businesses are allowed to return to their normal commercial activities, that these employees can then commence or recommence their employment. The issue obviously is that these employees will not receive salary or wages during the lockdown period. And as horrible as that sounds, there is one or two mechanisms that the government has recently implemented that would ease the burden on employers and employees alike. So on the 26th of March, the government published a directive which created the Employee-Employer Temporary Relief Scheme. Now, what this essentially does is it allows an employer to place their employees on unpaid leave, and the employer and the employee can then make application to this temporary relief scheme through the auspices of the Unemployment Insurance Fund, or the UIF, and they will then ensure that employers are paid a certain lump sum in terms of various formulations and calculations that need to be applied, and the employers in turn will then pay these amounts out to the employees in the form of either wages or salaries. So we also recently published an article on our website, I think if I'm correct, it went up either yesterday or earlier this morning, which deals with that particular directive and how employees and employers can go about applying for that particular benefit in terms of the Employer Temporary Relief Scheme. It's very straightforward. It literally requires an employer to address a particular type of email with various required attachments to a specific email address. That email address will then kick back an automated response to the employer with an itemized list of the steps they need to follow, the documents they need to submit, and the process can then follow from there. So ultimately what this is aimed at doing is to take some pressure off employers who are struggling to meet their creditors, rental and employee staff wages and salary demands, and then also ensure that employees receive some form of financial relief during these uncertain times, with a view to either not crippling the business of the employer or ensuring that an employee still has a job by the time that the lockdown finishes. So yeah, very interesting area of the law, a lot of developments, and as I said previously, this area of the law, and I think very few areas of law were prepared for this type of unforeseen scenario that we're facing. And ultimately, this is a work in progress. Government is actively trying to find solutions to existing issues that have come about because of the lockdown, and hopefully this will assuage some of the employers' concerns and employees' concerns regarding financial matters. So if you need any further information on this particular topic, please post your comments in the comment section on the channel, and we will answer them as they come up. Matthew, I don't know if you have have something to add?
Yeah, so sorry, just from a very a more boring point, I'm just getting some report back from clients saying that the connection is unstable. I'm going to try and see what I can do my side to sort it out. So if you are experiencing lag or latency on your side, I do apologize. You will see from the video description that we are getting affected by the West African cable line, which is down. It's unfortunately, this is the highest speed available to us at the moment. So Peter, I wonder if you could perhaps just continue chatting on some of the questions that you've been asked. I know that you've been asked not only about employee retrenchments, but also along the lines of what an employer is required to do in terms of ensuring a safe workspace. And I know that in as much as the lockdown has clarified a lot of those questions for us, in that it's absolutely enforced aside for employees who are rendering essential service. Obviously, once the lockdown ends on April 17th, employees are going to be sent back into offices, and they may or may not have an issue with returning to a workspace which is potentially unsafe or may expose them to the virus. So if you could just take us through that. I know you wrote an article on that earlier on, before the period of the lockdown. If you could take us through that. I'm just going to quickly see what our clients are saying as to the technical issues. Thanks.
Okay, thanks, Matt. So just to give you a short explanation, a bit of information as to what Matt is mentioning there is, obviously those employers that are remaining in business and are continuing trading as part of employers or entities that fall under the definition of essential services. So those are, for example, grocery outlets, medical services, legal services, certain sections of the transport sector that are transporting essential workers to their employment areas and back. So yeah, for the majority of small to medium enterprises who are considered non-essential and have been forced to lock down along with the national lockdown, there's obviously the issue regarding safe working conditions has been rendered somewhat moot. Those who are continuing their functions, and especially given the rapid spread of the pandemic through South Africa, I think I've been having a look at the news and the numbers have just jumped up exponentially over the last couple of days. They are required under our law, especially under the Occupational Health and Safety Act under Section 8.1, to provide a safe working environment to their employees. In these times, it is obviously then important for employers to acquaint themselves with the virus, how the virus spreads, and what type of safeguards they can take to at least minimize the risk of infection to their workers whilst they are in that particular workplace. So as we all know, hand sanitizers and regular hand washing is the best and most important way to deal or to prevent some form of infection where social distancing is not possible. So with employees who find themselves having to restock pick and pay shelves or are selling dog food or whatever the case may be, these guys have to ensure that there is particular policy in place in their particular workplace to minimize the risk of infection. So this would require some basics and common sense steps, such as ensuring that there's hand sanitizer frequently available throughout the store at various stops. I managed to get myself to Pick and Pay yesterday, and I was actually quite impressed by how they manage their operations. There is a designated individual at the front of the shop to spray your hands with sanitizer. As you get halfway through the stores, you work way through the aisles, there's another one or two walking around with hand sanitizer spraying people randomly. And when these types of scenarios and these types of measures may seem somewhat severe, but we are facing a severe situation, and these types of measures are required. So, also dabbling in the labour law sphere, I also kept an eye on how the remainder of the employees, especially those working behind, tellers, deal with their particular stations, and I was very impressed how they managed to wipe their stations with antiseptic materials after every single customer has gone through. Many of them wear masks and wear gloves. So those are the types of policy considerations that the employer would have instituted all employees would be required to wear masks, all employees would be required to wear gloves at all times, they need to regularly sanitize, especially those who actually come into contact and deal with goods that they pass to customers themselves. So not only does the requirement on an employer to provide a healthy and safe workplace require these types of preventative measures, as I've just discussed, they would also require an employer to ensure that in the circumstances where it is determined that one of their employees has been infected with the virus or has been in contact with someone who has tested positive for the virus, that there are measures in place to ensure that that person is immediately secured, and any and all tracing mechanisms for them to ensure that any other employees that they may have been in contact with is also implemented. So this type of thing would be regulated through an updated employer policy, which would set out the steps that the employer would need to follow should one of these types of circumstances arise.
Peter, I understand that, or I know that I've had at least 2 clients approach me to discuss employment policies. I know that we've started working on one. Are you currently busy with something like that at the moment?
Not at the moment. At the moment, the majority of the work that I have that I'm assisting clients with in the labour law area is with regards to employee relief, how they ensure that their employees are adequately remunerated, especially in the circumstances where the employer themselves cannot do so because of the lockdown.
Okay.
It's been quite interesting that we haven't had many instructions come about regarding workplace policy, but I can only assume that the reason for that is that the majority of entities and businesses fall under the umbrella of a non-essential entity, and therefore they've had to close their operations. So for them, developing a policy now to deal with safety and
perhaps not necessary just yet.
Be a top consideration.
Yeah, I think it's probably a good time to mention, obviously internally as a firm, we have been confronted with these regulations and what is it's a novel coronavirus, and it's very much a novel legal position. So I think in the very early days of the following Ramaphosa's announcement saying that there will be a national state of disaster declared, and then later the lockdown, there have been quite a few articles and opinions being written on some very handy newspaper and news sources. But I think it's fair to say, from an attorney's point of view, that this is unprecedented. We can, to a large extent, we can comment and we can advise as best we can, but there is very little in terms of precedent as to this current situation. I think it's quite relevant for our viewers out there and our clients to realize that, for example, the act in terms of which the national disaster was declared is a 2002 act which came into effect in 2004, and in that time the only other national disaster that has been declared was the national drought. It's obviously a very different type of disaster, and certainly didn't lead to anything anything along the lines of imposing a limitation on gatherings, or certainly nothing like a national lockdown, in terms of which people are not permitted to leave their own premises. And I use the word precedent, and that's, as you know, that's what we as attorneys fall back on when we are asked to advise on something. The legal position is almost always catered for in case law, and here we have an act which, as I said, was only brought into force in 2004, meaning that there's not, as a natural consequence, there's not going to be a lot of case law on it. The only proclamation of the national disaster in terms of the water crisis has no similar precedent. There's been no case law that was developed on that subject. And even when we look at topics like supervening impossibility, which have been thrown around in a lot of these articles, the case law dealing with this sort of thing, if we look back, we look at case law which dates back usually to the First and the Second World Wars, which again, that situation is not actually comparable to what we're dealing with now. Even during the world wars, you would have heard from parents and grandparents that even during that time, there was no limitation placed on your ability to leave the house or to interact or to conduct a business. Quite the opposite. I think at the time, during wartime, if anything, you are encouraged to continue businesses. So we find ourselves in this very unique position, advising very much on a case-by-case basis, because we've never seen anything like this. Our legal system has never encountered anything like this. So it's been an interesting time. I think you're the same as me. I've been waking up every morning with my coffee, reading the regulations. And if you look at a normal day for the Government Gazette, maybe you're getting a Government Gazette sort of once a week, maybe new regulations once every few months, and we have plenty of time to deal with the situation. We have plenty of time to consider the legal effects of the regulations, often before they come into effect. Whereas here we have a very unique situation in that there seemed to be a pattern of a minister makes an announcement on a Sunday, and perhaps Tuesday or Wednesday we're told that the regulations have been published, and on that date those regulations become effective. So it's been a very interesting time just as an attorney to live and work through the lockdown and the national disaster, because each day we are required to interpret new law and to advise on a situation where we don't have recourse to a specific and individual case precedent on each of these topics. I do see, sorry Peter to interrupt, I do see that there has been a comment which I believe will be aimed at you. Zizipo asks, am I obliged to make remote working available to my employees during the lockdown? It's an employment topic, so perhaps you can, the floor is yours.
Great, nice Zizipo, thank you for your question. It would depend on one or two things. Firstly, it would depend on whether you are a non-essential employer or not, whether the services that you render are considered non-essential or essential in terms of the regulations.
Peter, so sorry to interrupt, and I realize there's a bit of a lag. Would you mind just sharing the regulations so that I can follow and the viewers at home can follow? As I understand, essential services was defined in one of the recent regulations.
Okay, so all of you should now be able to see the regulations that I've shared. So
yes, I've got it up on my side.
Okay, so let's just scroll down to what has been defined as an essential service right now. So if you look at the definition under Chapter 2 of the regulations, it says essential goods means the goods referred to in paragraph A of Annex B. So this is the essential goods. We are dealing with essential services now. So essential services means the services as defined in Section 213 of the Labour Relations Act and designated in terms of Section 71 subsection 8 of the Labour Relations Act, and as listed in paragraph B of Annex B, as may be amended from time to time. So just to give you some clarity on this, so what this particular definition tells us to do is to first look at how essential services are defined at Section 213 of the Labour Relations Act, and that definition is then bolstered or added to by the addition of those particular services set out in paragraph B of Annex B of these regulations. So what I'm going to do first is I'm going to bring up Section 213 of the Labour Relations Act to show you how that particular act defines an essential service. Just give me a few seconds here just to bring it
up. Peter, sorry, for what it's worth, I have managed to work out what happened with the link that viewers were struggling with. As I understand, our admin team is busy sending a new link out to clients and people wanting to watch.
Okay, great, thanks. Okay, so what I'm doing now is I'm bringing up, you should all be able to see this little extract from the Labour Relations Act. So here we see essential service as defined in Section 213 of the Act. Very limited definition you will see. It simply deals with a service, the interruption of which would endanger the life, personal safety, or health of the whole or any part of the population. So a very broad definition there. And then parliamentary services, South African police services. So because this is such a broad definition, what has happened is that government felt in the regulation they needed to expand on it to give everyone some idea as to what this really entails. So what I'm going to be bringing up now is we're going to go back to the lockdown regulations. I'm going to go to Annexure B, paragraph B. So you should have in front of you now what is considered essential services during the lockdown. I'm not going to read.
Sorry, Peter. Sorry, I'm going to continue interrupting. You can tell me if it gets annoying, but that page isn't currently being shared. If you could just pop it up on for the viewers to see at home.
Apologies.
I'll let you know when I have it on my side and it's visible to the people at home.
Sure. Okay, Ron, you should be able to see the regulations now. Matthew, can you see it on your end?
Yes, I've got it. Go ahead.
Okay, so I'm going to go down to Annexure B, paragraph B, just to give an idea as to what is considered an essential service during the lockdown period. So here they are. A whole host of them. I don't think it's necessary to run through every single one of them, but you'll see obviously medical and health services are included, disaster management, fire prevention, firefighting, production and sale of goods listed in category A above. So if we go up, we can see food, cleaning and hygiene products, medical services, fuel including coal and gas, and basic goods including airtime and electricity. So yeah, quite a few services are entitled to remain operational. You'll see attorney services, legal services been included into that as well. Unfortunately for everyone, SaaS services are continuing to run as well. So if you find yourself as an employer running a business that provides the services listed in this particular paragraph, so anything between point number 1 to point number 28, then you are still entitled to operate your business during this time. So what this entails, and getting back to this question, is if you, with the services that your company or your entity provides to the public is or falls within these particular regulations set out here, point 1 to 28, then you're entitled to operate your business, but provided that you can operate that business remotely, you should do so. So, Zipo, if you find yourself offering an essential services and you do have the means to allow your employees to operate remotely, then you have the ability to order them to do so. You can do that under the auspices, as I mentioned earlier, of Section 8, Subsection 1 of the Occupational Health and Safety Act, which places the obligation on you as the employer to ensure that you provide a safe working environment. So if you can still operate your essential services business during the lockdown, and you can do that remotely, then you would more or less be under a duty to ensure that you do so. If your services cannot be provided remotely, and you are still allowed to trade under the regulations published, then your employees will have to come to work.
Okay, thanks for that, Peter. I just see that I have an email coming in here from a client who perhaps has misunderstood how to use the comments mechanism. I'm happy to explain it at a later stage. But a client who runs a chain of restaurants has asked what my views are on rental payable for retail tenants during at the time of the lockdown, and also at the time of the national disaster. So I think in many ways the lockdown has brought some level of clarity to some of the questions that we were being asked. So you would have remembered that when President Ramaphosa announced the national state of disaster, that those disaster regulations came with what people were calling safety measures and social distancing measures. So we had a prohibition, for example, on the number of persons that could gather. Now, that gathering under the initial regulations was set at 100 persons. And obviously for many businesses, a number like 100 makes your business very unprofitable. And we, on the announcement of those regulations, we were getting asked questions like this, to essentially saying that taking into account the fact that perhaps I run a restaurant that seats 200 persons, I'm going to struggle to make rental payment under those conditions. If I'm servicing half the clients, do I have an excuse for not paying full rental? So that introduced a question which will apply, or which has applied prior to the lockdown and will apply again after the lockdown. As you know, the lockdown is scheduled to end on the 17th of April, whereas the national disaster will only end on, I believe it's June the 15th, 3 months after the disaster was declared. So I think if I were to break up the question into two, I think, as I said, the lockdown has introduced a measure of clarity for us. If you were operating a restaurant under the national disaster, you had a decision to make. Do I go and incur the costs of keeping my staff on premises? Do I continue buying supplies? Do I continue trading as much as I can? And for a lot of our clients, the answer was, we're going to do the best that we can. So we'll have less than 100 persons on site. We'll abide by the liquor regulations which were introduced. We won't sell liquor after 6 p.m., etc. Obviously, that has an impact on turnover, but it's a decision you have to make as a business. The lockdown makes it in ways a lot simpler, because the answer is you cannot trade. You are either an essential service and you can invite people in, or you can't. There are, I suppose, exemptions in that you can write to the DTI to obtain recognition and certification as an essential service, but really it's essential service or not. So for example, the client who's just mailed me about the whether or not he can continue, whether he's entitled to a reduction or remission in rental. For the period of the lockdown, it's probably a much cleaner answer in that he cannot trade. Whereas in the disaster period, he had this sort of discretion which we were a little bit unsure of how to handle. I'm going to delve into very, very briefly the legal, some of the legal jargon and the legal principles behind this question, and then I'll get to a more practical answer, I hope. But look, essentially, when we look at contracts where we have reciprocal obligations, so for example, in the example of a tenant and a landlord has basic obligations like providing vacant occupation of premises to a tenant, and a tenant has basic obligations like the payment of rental. These are the two sort of obligations which we find at issue here. Now, what our clients seem to be asking, and what I'm sure many of you out there are confronted with, is this idea that you are not allowed to trade during this period. So the question then becomes: is what do you do with your the rental that you owe? Now, in a normal environment, you would only where we deal with the issue of supervening impossibility. So it's something which was outside of the control of both parties, which prevents one or other party from performing in terms of the contract. So the most practical example is the one at hand. If I run a restaurant whereby I'm supposed to allow people in and out of the business, out of the premises, the lockdown regulations make it impossible. It's legally prohibited for me to do so. So in other words, I'm stopped from performing performing the business that was the subject of the contract. So at this time, we have a similar prohibition on the landlord in that he might be prohibited from letting persons into the rental premises. And I think what we've been advising clients, and what I think is sage advice during this time, is that there is no blanket prohibition. There's no blanket set advice that we can give. it's very much a case-by-case basis that we have to deal with during this time. So, if you are a restaurant, you are prohibited from trading. Strictly speaking, there's nothing that's stopping you from paying rental, and there's no reciprocal, or there's perhaps no reciprocal obligation which the landlord is stopped from performing, which would then excuse your performance. So the classic mechanism by which we find force majeure, or supervening impossibility affecting obligations, is if it stops one party from performing, then that party is excused from his performance. So it is a very tricky question for tenants at the moment. I think on a more practical level, I think all tenants should be considering engaging with their landlords. I think there's a fair amount of understanding out there from retail and commercial landlords. So I think where possible, you should be reaching out to your landlord and asking to negotiate on rental amounts payable. This is particularly so if your business has been stopped from trading, and that's impacted your ability to perform in terms of the contract. So I know that, for example, this is being encouraged from a government perspective, in that we have the Department of Trade and Industry that has released regulations which have exempted parties from the application of Sections 4 and Sections 5 of the Competition Act. So if I can take a step back, the Competition Act deals with restrictive, horizontal and vertical practices, or prohibited practices, under Section 4 and 5. And what we usually find is that parties are prohibited from colluding on prices. You don't want, for example, all grocery stores colluding to limit their prices at a certain level. It's anti-competitive. And you can also have similar anti-competitive effects where parties operate in a vertical relationship, so supplier and customer. Now, what the effect of the DTI regulations on the exemption from those sections are, is that when done at the request or with the involvement of the DTI, it's a little bit tricky wording, and we have actually written to the DTI to resolve this conflict, but when involving the DTI, the idea is that tenants and landlords are encouraged to get together and set prices to deal with this to deal with the difficulties over this time period. So if I was a tenant, I would be writing to my landlord and I would be requesting a reduction in rental, or at least a negotiation along those lines. And if possible, I would be writing to him to invoke the exemptions that have been brought about by the DTI regulations, to try and set a price just for the period of the lockdown and for the period of the national disaster. So I hope that answers your question. I think maybe as a general note, if you have any specific legal advice or questions or issues that you'd like us to discuss, I mentioned it earlier, but please have a look at our YouTube channel and at our website. You can contact our attorneys there, or you can contact us via the YouTube channel. Peter, I see that we have another comment, this time from Kate Otto. And she asks, if my team is able to work remotely, is it the employer's responsibility to provide internet, or is it for the employee to provide this? I think it's a question that's coming across a lot at the moment. And then Kate, who seems quite active on the comments, also asks, so Peter, you're just going to have to minute that first one. She also asked, her husband is currently on unpaid leave, and therefore we do not have enough to cover all our bills, and banks have not responded to requests for holidays. Why don't we start with yours, the working remotely and the obligation of the employer to provide internet, and then I'll have a few words on the second part of her question.
Okay. So thank you for your question. It's a bit of a novel question. So, I mean, thinking about it practically, I would think that firstly, should your employer, or should the relevant employer, be someone or an entity rendering essential services during this time? And should they order their employees to work remotely, which is not regularly a requirement of the job, and was not necessarily included with in the employment contract, or does not necessarily deal with you having to work remotely, then I would think if that would create some form of undue cost or financial implication for the employee, that it can be required that the employer would have to cover that cost. So I mean, it would all come back to, as Max mentioned earlier, it's very much a fact-by-fact, case-by-case type determination that you would need to make. What is the nature of the job that your employees perform? Is it something that they would regularly be required to perform remotely? Is it something they can perform remotely? And in these times, if it can be done, and if it is an essential service that's being rendered, and where this type of issue was not previously raised by an employer or required by an employer from an employee, then I would think that the employee would be able to make a solid argument that the employer would be liable to at least cover the basic cost of internet required for that employee to render the services that are required to render.
Yeah, I think.
I hope that answers your question.
Yeah, I think from a contractual perspective, anything that represents a material change in employment conditions would need to have been agreed up front. So I can't recall in any of my recent employment contracts a term stating that I would have to have my own internet. I've seen own transport, that sort of thing. It's perhaps something that people are going to consider including in their agreements moving forward now that we've gone through this exercise. I mean, as we said earlier, nobody has any experience of this. Nobody's ever been forced into a national lockdown before. So I think there'll be quite a bit of sort of revisionary work which will be undertaken at the end of this crisis. I think in as much as it's impossible to prepare for this one, you would think that parties now start including things like force majeure clauses, dealing with national lockdowns, perhaps more comprehensively than we've seen. So I'm going to go off topic slightly, but just on the subject of force majeure clauses, we've seen that many of them deal only with specific instances of force majeure. So the sort of classic ones are fire and flood and political instability, those sort of things we see fairly commonly. What we don't see is national lockdowns imposed on the basis of or as a result of a Chinese originating super virus. It's very, very much an unprecedented and novel situation that we find ourselves dealing with. So you will find that many people are testing their force majeure clauses, and you'll also find that many force majeure clauses aren't going to stand up to the test. A lot of them, when you deal with force majeure, one of the legal requirements is that the force majeure in question was unforeseen. So we deal with the foreseeability test, and the point of that test is to say that if the act of God was foreseen, then the parties are not going to be excused from performing in terms of their obligations. Whereas if the act of God was something outside of the contemplation of the parties at the time that they contracted, then you might well find that parties are excused. I had the example thrown at me only this morning that in the context of an earthquake, if an earthquake happens, is it different whether that earthquake was expected or whether that earthquake was unexpected? And my answer is yes, because it has an impact on the foreseeability test. So if, for example, you lived in California and it's a normal circumstance to have rolling earthquakes from time to time, perhaps you have low-level structural damage to your property, that's a very different scenario to an earthquake occurring in South Africa and perhaps a whole building is destroyed. So this idea of force majeure, it must always be weighed up against what was foreseen by the parties, because if the parties have foreseen it at the time of concluding the contract, then generally they are going to be held to their performance even though the event has happened. Whereas if something has come out of the blue which was outside of the contemplation of the parties, and perhaps would have impacted does impact their ability to perform after the event has taken place, then force majeure does or may have the effect of excusing you from your obligations. I just want to quickly address Kate's questions. Then I see we do have some other questions coming in. Kate.
I also have a question that came through via email, Matt, that I want to deal with after you've dealt with
Okay.
Kate's question.
Perfect. Kate asks, my husband is currently on unpaid leave and therefore we do not have enough to cover all our bills and banks have not responded to requests for holidays. What is the implication? I think, sorry, just on an entirely not a legal point, it looks like all of the banks are now offering some sort of relief over this time period. I think FNB was slightly late to the party, although I did see on News 24 this morning that they have now offered some form of relief. So I would think that if your banks haven't already offered relief, I do think that the sort of public relations nightmare that awaits them if they don't offer, in the context of all of the other ones having offered similar relief, would prompt them to do so shortly. I think to your question, it's unfortunate that your husband is currently on unpaid leave. I'm not sure what Peter would say about that. You might, as I understand, I don't think it's fair for employers to put employees on unpaid leave at this point. Peter, is that correct?
At the moment, they may, because of the lockdown, they would be able to argue that if they are a non-essential service and they are not allowed or entitled to generate any form of income with which to remunerate their staff, then in order to kind of, how can I say, preserve the business as a whole and to try and prevent it from going under via liquidation, and in order to maintain the majority of the integrity of their workforce, that they may do this. These are
extraordinary times.
Novel circumstances. The normal labour laws have been somewhat changed and amended and made somewhat more flexible during if your husband finds himself in a trade or a sector that is considered non-essential, and should his employer believe itself incapable of meeting the various rental creditors and employee demands on its finances, then they will be entitled to do this. But as I mentioned earlier, there are other options available, especially to employers who find themselves incapable of satisfying their employee wage and salary demands. So, and I'm just going to reiterate something that I mentioned earlier. On the 26th of March, a directive was published by the Minister for Employment, and what this directive pretty much allows, it allows an employer to make an application to a newly developed employer or employee temporary relief scheme. So this will allow employers to make application, and if their applications are successful, luckily the bar has been set quite low for these applications, this employer will then receive some form of monthly dispensation or weekly dispensation from the UIF to assist their employees up to a maximum of, if I recall correctly, at 17,200 Rand per month per employee. So there is that option available, and if you and your husband get to the point where you need something like that to be implemented and you need your employer to step in, I would recommend that you take this up with your employer, advise them of the creation of this new scheme that can assist and require that they implement that.
Okay. Maybe just to round out the rest of Kate Otto's question, she asks that they do not have enough to cover all our bills and banks. All her bills. What are the implications? So, as Peter discussed, there's various relief that it may be available to the employer itself to assist in paying out salaries. I do think that as much as we're going to see revisionary work on contracts and agreements after this, I do think there's going to be a fair amount of litigation and perhaps approaches to the CCMA and to bargaining councils from a labour perspective to correct or claw back amounts which weren't paid over this period. We hope that parties...
Just to step in there, and you made a good point there, is that, it's a lot of this will lead to some form of labour law litigation after the lockdown has been dispensed with, I'm sure. But there are some bargaining councils and certain trade unions that have taken the initiative and have all entered into some form of agreement with the Department of Labour and the DTI, whereby they agree on a set wage or salary structure. So, for example, SOCT, with the clothing industry union, has recently had a collective agreement published by the Department of Labour, in which they set out the regulations regarding the temporary relief scheme and how that particular sector will be dealing with payouts and the amounts of the payouts. So very interestingly, what has been agreed there with the bargaining council for the clothing industry is that the employer will pay week one worth of wages for during the lockdown period. The employer will pay half of the second week's wages. The UIF or the Department of Labour will then step in for the other half, and then weeks 3 and 4, if I recall correctly, will be covered by the department itself and not by the employer. So those types of smaller intermediary agreements that define large-scale and broad-scale directives, such as the temporary employer release scheme, will be very important to kind of minimize exposure to employers going forward, where the various trade unions take it upon themselves to negotiate with the employer and the Department of Labour to kind of fine-tune the broad strokes relief measures.
Yeah, I think it's probably also worth noting that in as much as we as we said, this is an unprecedented scenario that we're dealing with. So invariably, if someone doesn't pay someone, it gives rise to some sort of dispute, and you would expect that a fair amount of litigation and referrals to these councils, etc., starts happening. Perhaps not during the lockdown, but shortly thereafter. I think on a very practical note, it's probably a good time to explain that as of the regulations, the directives issued by the Minister of Justice, Ronald Lamola, on Thursday, the 26th of March, we've got a very unique situation imposed, which to my mind hasn't happened, certainly not in the time that I've been practicing, in that all of the court rules, all of the time periods now imposed by the rules have been suspended until the end of the lockdown. And we essentially are limited to urgent matters and matters which involved essential services. There's various criminal matters which have also been suspended. You'll find that awaiting trial detainees are limited to a number of applications, notably bail applications. But it's an indication that the Minister of Justice, in consultation with the Chief Justice, has recognized exceptional circumstances, and particularly in view of the need to for social distancing measures and safety measures, the regulations and directions have been published to ensure that the disease is not spread in our court. It's probably an interesting point, but the limitation of the right to access courts in both a civil and a criminal context affects our constitutional rights. Peter, as you know, having lectured on the subject, Section 34 and Section 35 of the Constitution, it's Bill of Rights, and I mean any right in the Bill of Rights can only be limited by in very limited circumstances, and I think you will see a few challenges happening over this period because you have it's central to our Constitution and our Bill of Rights that parties can approach the courts. So certainly from our side, from a litigation perspective, it's interesting because it's only really our urgent matters that are going to go ahead, and perhaps also if there's litigation related to essential services. But aside from that, all of our civil matters are being postponed. Instituting summons, for example, if you weren't paid in March, you might want to approach the CCMA, or you might want to approach the Labour Court, both of which have been suspended during this time. So you're going to have to, your relief is unfortunately going to have to wait until after the lockdown period. Peter, there are some questions coming up here from a Labour perspective. Could I run them to you?
Can I just deal with one question quickly that came through from a client a while ago? It's actually quite an interesting question, a simple answer, luckily.
Yeah, sure.
A client asked whether he or she can be evicted or their home repossessed by the bank during this period. The short answer is no. Luckily, the Minister of Justice had recently declared a moratorium on all evictions and repossessions. not indefinitely, unfortunately. These will lapse on the 17th of April. The moratorium will lapse, depending on whether the executive decides to extend the national lockdown or not. So at least up until the 17th of April, those who are facing residential eviction or bond-related repossessions will be safe.
Okay, Peter, so there's quite a few comments which are coming through now. I see people are connecting to the correct stream. I know that we'd initially discussed holding this webinar for an hour. Are you happy to run over a little bit, maybe 15-20 minutes, and just if it gets to sort of 1:30, I think we'll have to call it time for the session, and perhaps we can answer questions during another session. But let's try and answer as much as we can while we have a captive audience. So I have a question here from a Megan who asks, if I have a small catering business, am I allowed to simply keep my doors open during lockdown? Very, very quick answer would be no. However, I will take you to an exemption shortly. She has a second part of this question saying, should I get some sort of permit or permission from the government? So I am just going to open up my regulations here. I hope you can all see this. So if we look at the final regulations which were published in relation to the lockdown, you'll see that in Annexure B, categorization of essential goods and services during the lockdown, you'll see that under so Annexure B A1 I is food, any food product including non-alcoholic beverages. So I'm just going to minimize that. So Megan, to your answer, if you are providing food services, then obviously the government is very aware that you cannot cut off food supplies to persons who are working or at home during a lockdown. So if you were providing food, you'd probably be fine. A catering business is somewhat different. And I would probably think that a catering business is one of those fringe industries that perhaps need to consider writing to the DTI for clarification. I will link the DTI's website after this, but essentially businesses have been given a set of contacts, a list of email addresses which they can use during the lockdown period to both apply for exemption. So you mentioned here, should I get some sort of permit or permission from the government? The DTI is the section of the government that you should be talking to. And you can ask for clarification on some of the regulations that have come out. That ends up being a similar question to a Brendan Lennox, who asks, if you are stopped and held in a roadblock for whatever reason, even as an essential services provider, what would your options be? Our staff are concerned regarding this. So you would have seen that there's been there is a form dealing with this in the regulations. I'm just going to pick it up again. Brendan, to your question, I would suggest that your employees are issued certificates, issued letters by the company after you've clarified with the DTI that you are in fact an essential service. If you haven't managed to contact the DTI yet, I imagine they are inundated with queries. Then certainly a letter stating why your employees fall within a category of essential services would be a good idea. I think in the enforcement of these regulations, there's going to be a little bit of leniency in these earlier days before everyone is able to get their paperwork in order. As we said, these regulations came out on Thursday, which means it's only really been 2 business days for parties to get their documents in order. But I would certainly think writing to the DTI to clarify that your business does indeed fall into a category of essential services is advisable, and then providing anyone who's going to be out on the road and who might be stopped with a letter or certificate stating that they are allowed to travel. there is that's not a question, that seems like just a comment. Miss Otto says thank you. Arinda asks, if my commercial lease in a mall comes to an end in 3 months, can I use the current circumstances to terminate it early without penalties? I'm not an essential service and I can't keep my shop open. We spoke earlier about retail property tenants being able to apply for rental reductions. Here we're dealing with something different in that you're asking whether you can terminate the lease entirely. So I think this is a question that I've personally been asked. It comes down to this issue of supervening impossibility, and we discussed the issue of foreseeability. Another issue which rears its head when we consider impossibility is whether it's partial and whether it's temporary and whether it is a permanent state of impossibility. So if we look at, for example, the original regulations which came out stating that you're going to be limited to 100 persons or less, a gathering is limited. Let's say, going back to our previous example, that you run a restaurant which seats 200 persons, or you have a commercial lease in the mall and you usually cater for up to 200 persons. Now, the limitation to 100 persons doesn't represent a full and comprehensive impossibility, because you can actually trade. You would be able to trade and just limit the number of persons in a store to 99 persons. During the lockdown period, we have a scenario of complete impossibility, in that you may not have those persons in unless you are one of the exempted essential services or you're selling food, etc. But you run into a scenario where that impossibility is actually only a very finite period of time. It's 21 days. When we come out of that 21 days, you're going to be able to trade to some extent. You obviously will have a reduced, you can expect a reduced customer interaction or customer visits to your store, because the social distancing measures will still be in place. You'll still be limited to 100 persons. So in that scenario, I would think that you don't have an impossibility which would suspend or excuse you of your performance in terms of the contract yet. If, for example, the lockdown period were to continue for 9 months, the way that we would look at the impossibility which your business is affected by this crisis, it might be that our law, in considering what is objectively reasonable to the parties, would say that it's not reasonable that a party to a lease agreement is made to pay for that lease agreement for 9 months and to continue with their contract. So it really comes down to the extent of the impossibility. Again, we don't want to advise too closely on questions like this. It's for discussion. We would encourage you to get in contact if you have if you would like us to assess your contract in light of the current circumstances. But on the very little that we've been told, I would probably say that you are not entitled to terminate early without penalties just at the moment. But yeah, as we said earlier, complex situation, unprecedented. You'll have to, in some ways, sort of take it day by day and see how this lockdown and the crisis plays out. I'm just going to quickly catch up on comments here. We have a question. I'm not sure if it's a question, Peter, but I'm going to read it out anyway. Huge levels, Taryn Lynch says, huge levels of complexity handling the special leave for self-quarantine is a big issue, especially for essential services companies. It could run into big numbers if we promise to pay indefinitely. So I suppose she's asking there about special leave in particular, and it looks like, it sounds like she's talking from an employer perspective, saying that it could run into big numbers if we promise to pay indefinitely. So perhaps you could just give your thoughts on special leave and this idea of promising to pay indefinitely. I would think that when we use that word indefinitely again, you stray onto what I was talking about in the context of the lease agreement, in that over a period of time, if the impossibility stays with us, then it may become objectively reasonable to terminate a contract in those circumstances, but I'll leave it to you.
Yeah, and it also, I would guess, depend on the type of leave that this person wishes to take. I mean, if you're dealing with an employee who is not infected with the virus, or is not sick in any way, but is looking to preventatively self-isolate, then the situation becomes quite complex, because ultimately they're not sick, so they're not entitled to sick leave. And if you want to look at it in black and white, then technically that employee should take either leave, paid leave, or if that is not available, then that employee should take some form of unpaid leave of absence. But this is where, as you mentioned, things become slightly complicated, because I can understand for the employer that does not wish for each and every one of its employees to believe that they need to self-isolate and take off a week or two of work, even in the event that they do have the leave. That would be crippling. So what can be done in that type of scenario is the employer should technically then consult and engage with the employee, mention to the employee the realities of going on annual leave during this specific period for, let's just say, 2 weeks, in order to self-isolate, but where the existence of an infection or of COVID has not been established. In that scenario, the employee would technically have full right to take annual leave, but the employer should negotiate or consult with the employee so they can at least agree on some form of unpaid leave, whereby the annual leave is then at least kept intact should the employer require such annual leave after the lapse of the lockdown or the eventual lapse of the state of disaster. But ultimately, this becomes an issue for consultation between the employer and the employee. If the employee wants to take preventative leave to self-isolate, and they do have annual leave available to them, then I can't see any reason or any basis for the employer refusing that request. But should the employer believe that they firstly cannot do without the services of that particular employee, or if the financial burden on the employer to pay annual leave during this period for no return with regards to work rendered, then I would recommend that some form of agreement be reached, the agreement be drawn up and signed and annexed to either the employment agreement or kept aside. Unfortunately, ultimately, if you're working in an essential business delivering essential services, and if your employees who do have annual leave due to them want to self-isolate for 2 weeks in order to prevent possible infection, then they would be entitled to do that. I would think that the only way in which the employer can get around that is to negotiate and consult with the employee, ensure that the employee knows the financial realities of placing that employee on annual leave, and try and circumvent that further.
Yeah. So I'm just trying to catch up with questions. I see we have a comment here which has come through on my email, and that's from Brendan Lennox, who asked earlier about travel permits and that sort of thing. He mentioned that he has already got documents in place, but that his staff are concerned that they potentially get held. So look, if you have the correct documents in place, then there's not much more that you can do. Especially if you've contacted the DTI and that you have confirmed that you operate a business which is classified as an essential service, I think all you can really do is reassure your employees, perhaps have a good attorney on call for if and when they get arrested or pulled over or stopped. But yeah, you can't sort of plan too far with that sort of thing. I'm going to try and catch up with comments here just as we go along. I have a query about the effect on sale agreements, which I think the context here tells me that it's in the context of conveyancing and property transactions. I don't profess to be an expert in conveyancing. If you would like to ask specific questions on that topic, I would suggest you get in contact with us and we can refer you to our conveyancing department. I would just say that from a general perspective, we know that the deeds office has been closed and some of its operations are limited. So you might well find that there are transactions which are delayed or postponed to a later date for registration. In as much as the sale agreement could be affected by a performance, I don't want to comment too much without knowing more of the specifics. So please feel free to contact us if you'd like more on that. We have a confirmation that Mr. Brendan Lennox got that question, so pleasure. He says thanks. We have a comment here saying, what would the impact on your rental be if you are left with no liquidity after lockdown? So I assume here that you're talking about the tenant. If you're left with no liquidity after lockdown, I suppose liquidity would only really impact the tenant who has an obligation to pay. So I think it's probably worth noting that in as much as you should be using this time to negotiate payment holidays with both your banks and the malls and the landlords or whoever else you interact with, this is an incredibly tough time in our economy. There are going to be cases where you can't make ends meet, where as a result of this, not just as a result of the physical limitations that have been placed on us by the lockdown period, the economic effects of this crisis are obviously very severe. We've already seen that we've been downgraded, but I don't think you've come to this channel to hear my economic views. The reality is that there are going to be businesses who are struggling during and after this crisis. I've already seen quite a large spike in queries related to business rescue and queries related to companies going into liquidation. I do think you will see quite a large increase in companies applying for business rescue over this time period. So from a business rescue perspective, as I understand, SIPC is allowing new business rescue applications to commence, provided that companies can provide evidence that the resolution has been duly taken. Business rescue is probably an appropriate mechanism to look at easing your obligations. It's probably beyond the ambit of this discussion, but very briefly, for those who are not familiar with the process, business rescue allows a company some respite. It offers a suspension and a sort of a stop on many of the obligations that a company has. And in that time period, an independent third-party business rescue practitioner is appointed to take over the running of the affairs of the company. It's a preventative measure, I suppose, in not wanting struggling companies to be put straight into liquidation. And I think during this time, in trying economic times, it could be a very effective tool and an effective remedy for companies who come out of this crisis, perhaps not with the liquidity that they had going into it. I hope that answers your question. If you do have further queries on business rescue or liquidation, you can contact us after the call. Peter, I'm just going to run through these queries, but I think we're about done. Do you have any queries your side?
None on my side.
Okay, sorry, I see that I have been emailed by clients who, once again, didn't quite get the YouTube comment memo, but perhaps we need to explain that better next time. A client has asked, am I obliged to pay my bond and car loan repayments at the end of this month? I will have money to do so, but I would prefer to keep my money for more important necessary payments in the future if things get tougher. So I think here the client is probably referring to the payment and obligation sort of holidays that we've heard Standard Bank and Nedbank and Investec and FNB discussing. I think, on a pure contractual basis, there's no requirement right now for those banks to do that. I think it's an incredibly positive step from the big banks to step in and allow some form of relief. I would definitely advise taking a look at the actual terms and conditions, or contacting your bank and finding out the scope and the effect of that suspension of the obligations, and not basing your payments and your decisions on the latest Business Day article, as helpful as they may be. I think get the full story. That's probably one of the takeaways that I've been left with over the last few days. We tend to have ministers and persons making big announcements, but really before we see the contract or the terms and conditions or the regulations or the directions, as the case may be, it's very difficult to act on those announcements. So certainly get in contact with your bank, see what they can offer you, see what the terms of that offer are, and then make the correct decision on the best information available. I think, to answer your question very simply, if you are offered some sort of relaxation like that, then yes, you probably could save your money for more important and necessary payments. But as I said, please do get a look at what your bank is offering. Another question on eviction from my home/office if I don't pay rental this month. I think, Peter, you touched on this earlier, so
yes, yeah,
I don't know if you quickly want to run through that again.
There's a moratorium on all evictions and repossessions until at least 17 April. After that, we'll have to see. It very much depends on whether the national lockdown period is extended. But for now, the Minister of Justice has limited it to the 17th of April, so everyone is free from evictions and repossessions up until that date. What happens after that is still up in the air.
Yeah, and I think you won't see many, or you won't see any new actions or applications for eviction issued until after the lockdown period, subject to the exception of urgent applications. In certain circumstances, landlords will be required to bring urgent applications. Things like land grabs, things like unlawful occupiers who are perhaps taken advantage of the sort of lack of persons or companies functioning in the inner cities, that sort of thing. I do think you will see, and when that happens, then by all means you do have access to the courts. You will be able to bring an urgent application, and again, we're happy to help with that sort of thing. I'm just quickly running through comments, and then we can wrap this up, Peter. I think the last question I have here is a follow-up question from Miss Taryn Lynch. She was the one who addressed you on the special leave question. She thanks you for that answer, and she also says, follow-up question, how do we navigate around the UIF claims and the TERS disaster fund? Would you like to quickly chat Taryn through those?
Yes, Taryn, I'll happily answer that. Let me just quickly bring up the actual directive that was published. So that will give us some insights as to the ins and outs of how the fund works and how it is supposed to work hand in hand with the UIF. So let me just quickly bring that up here. Okay, so now you should be able to see the directive that was published on the 26th of March.
Yeah, I've got it open here.
So if we scroll down, I think very importantly for Taryn's purposes, we just quickly need to look at the purposes of this particular directive. So the purpose has been stated as making provision for the payment of benefits to contributors meaning employers who normally contribute to UIF, who have lost income due to the COVID pandemic, to minimize the economic impact of loss of employment because of the pandemic, avoid contact, that's what will be relevant here, to establish a temporary employee-employer relief scheme and to set out the application process for benefits of COVID-19 pandemic and to alleviate the economic impact of COVID. So let's quickly look at how this temporary relief scheme will function hand in hand with normal UIF during this lockdown period. So very importantly, you'll see Regulation 3 says here, should an employer, as a result of the pandemic, close its operations for 3 months or a lesser period, 3 months obviously referring to the declaration of the state of disaster we're currently facing, the company shall qualify for the COVID-19 temporary relief benefit. Very importantly, it seems the company must have closed its operations due to the pandemic and not for any other financial reason de-linked from that particular issue. The benefits, which is obviously the payout that a distressed employer will receive from the UIF through the temporary relief scheme, must be de-linked from the UIF's normal benefits. So therefore, the normal rule that for every 4 days worked, an employee accumulates 1 day credit, the maximum credit days payable is 365 for every 4 years, will not apply. So what that means is during this time, and specifically with regards to distressed companies who are looking to make use of the temporary relief scheme to remunerate their employees, the normal UIF procedure in that situation will not function as you know it, as it did pre-pandemic. This is now replaced by the contents of this directive, and the benefits, as the state said, Regulation 3.3, will only pay for the cost of salary for employees during the temporary closure of the business operations. Quite clear. So employers are not allowed to make application for the temporary relief, receive those funds, and then use it for anything other but to settle employee remuneration. The salary benefits will be capped to a maximum of 17,712 Rand per month per employee, and the employee will be paid in terms of the income replacement rate sliding scale, 38%, 60%, as provided in the UIF Act. So this is something that was implemented pre-pandemic, and it has been going on for a while, this particular scale in terms of which employee remuneration is determined, and that at least will continue throughout this period. But maximum is now being capped at 17,712 Rand. Should an employee's, this is quite important, should an employee's income be determined in terms of the income replacement sliding scale fall below the minimum wage set for a particular sector, then the employer will be required, or the UIF be required to pay out to that employer an amount equal to what is set as the minimum wage for that sector. So if the amount determined in terms of the formulation set out in the directive is lower than the normal minimum wage for that sector, let's say you work in transport, then that sector minimum or sector specific wage would apply.
Peter,
So,
can I ask,
yeah.
I think a lot of these regulations, I think you're onto my question here. I was going to say a lot of these regulations to many people seem a little bit confusing. I see you've scrolled down here to application procedure. So can we assume that Taryn can get in contact with COVID-19 TERS at labour.gov.za?
That's it. So,
Okay.
so Taryn, the way you would navigate this temporary relief scheme benefit is to apply by reporting your closure. So the email that you sent through to this particular email address that I'm highlighting right now, it would have to say, I'm a small to medium or a large employer, I render essential or non-essential services, I have had to suspend my operations because of the COVID pandemic, and therefore because of the lockdown that was declared. And once you set that through, there'll be an automatic response setting out shortly the various criteria that you need to meet to qualify. So just a few of these, the employers will be required to furnish the unemployment insurance fund with the following completed documents: a letter of authority from the company, the signed memorandum of agreement from the employer or the bargaining council with the unemployment insurance fund. And then very importantly, an employee who is being paid by the employer during this period is not entitled to benefits. So this is where that issue that I mentioned earlier regarding a clause in an employment contract that allows an employer to unilaterally reduce working hours and therefore compensation will come in. So if an employer has that particular clause in their agreement, then they can set that and implement it directly with the employee by virtue of the operation of the contract. And that employee or that employer will then unfortunately not be able to make use of the temporary relief benefit because their employees are receiving some form of remuneration on a weekly or monthly basis. So this temporary relief scheme is specifically tailored for employers who have had to suspend operations in totality and are not able to compensate their employees at all during the lockdown period. I hope that sheds some light on your question.
Okay. I think it's approaching our hard deadline of 1:30. So I have one two queries from the same person here that have come through, and then unfortunately we're going to have to hold all other comments until the next session. I'm sure we will do another one. So that DJ guy comments, clients who are cancelling and not postponing events are asking for their deposits back, as it is unusual circumstance, as they cannot fly in for their weddings and events. We state booking fee. And then he has sent a labor query. I think what I'll do, sorry, that DJ guy, as I said, we've got 4 minutes and then we're going to have to end the stream. So that DJ guy, I'm going to put you in contact with Peter after this. He's asked the question on applying for the relief fund. So I think if I can link you two guys up, you can discuss it further. Just very quickly on cancelling and postponing events. This is actually something that I've been dealing with quite a lot in the last few days. You know, it really depends who I'm writing on behalf of. If I'm writing on the events organizer, I'm trying to limit the exposure that they have to clients in paying deposits back. And if I find myself writing for the customer or the consumer trying to get deposits back, I'm trying to get as much back as possible. So I think you have to deal with this on a case-by-case basis. I know we've mentioned it quite a lot, but it really is important to understand there is no hard and fast rule here. We can talk, you know, Peter and I have been talking in sort of general terms without an exact set of facts in front of us, without the agreements, etc. in front of us. So we encourage you to take these answers, then approach ourselves or, you know, your attorneys for more specific advice. I will just say that when it comes to the cancelling, postponing of events, you know, what we're dealing with there is this idea of supervening impossibility. We spoke about it earlier, the idea of an event outside of the party's control. You know, in the case of, let's say, a wedding venue not being able to provide the venue because of either the 100-person limitation or the fact that the lockdown has been imposed. Then in that instance, the event cannot take place. Now, when we look at supervening impossibility, we have to decide again: is it full? Is it partial impossibility? Is it permanent? Or is it temporary impossibility? So, on a case-by-case basis, you know, if you were to challenge that in court, the court would have to consider whether or not it is unreasonable on objective factors to impose that obligation on the parties. So if for example the event had to happen on such and such a date, then, you know, time is of the essence. There's that introduced into the contract. Then if the event company or the host can't host the event on that date, then I would probably say in the category of transactions where performance should be fully excused or discharged, and you would be entitled to your deposit coming back. That deposit back, by the way, is a very specific issue that is based on the fact that the contract is no longer in existence and you have a claim in what's known as unjustified enrichment. Yeah, I see a whole lot of thank yous coming through in the comments and on email and on WhatsApp. So I think it's probably that time, Peter, that we can close off today's session. I don't know if you have any closing comments.
None at this moment. Just thanks everyone for joining us for a chat. We appreciate it. And yeah, it was good to discuss some general topics that could be of use to everyone.
Yeah, from my side, thanks so much for joining. Peter, thanks for dialing in, and for clients and families and friends who joined. Thanks. It's really nice from our perspective. You know, we're all working from home, dealing with a very unique situation at the moment. So it's nice to, you know, free up an hour or two, you know, without having to charge for services, just to take people through questions that I think a lot of people are dealing with. I see. So yeah, the comments are coming through saying thanks. So guys, we appreciate you being here. Thanks a lot. And if you want to look at articles, if you want to look at material, you can head over to our websites. I will put a few more links in the description for this particular video, and then keep a lookout for more advertisements. We'll try and publish the time and the date of the next webinar. But yeah, thanks everyone. Keep well, keep safe, and stay healthy.
Thanks everyone.